Welcome back. You're still watching Politics Tonight, digging beyond the headlines. Now to our interview with the guest of the day. I am joined by President Bola Tinubu's lawyer, Wale Afolabi, for discussion on Atiku Abubakar versus President Tinubu and the facts of the Chicago certificate matter. Thank you so much for joining us, sir. Thank you.
Thank you so much for having me.
Right. So after a protracted legal battle, Chicago State University released President Tinubu's academic records. I'd like you to tell us how it all happened.
Well, a wrong information was planted out there that President Bola Tinubu did not attend Chicago State University. And someone sold that to Waziri Atiku Abubakar. And on that premise, he approached, through his lawyers, the High Court in Chicago, asking that his records be released to him because he had it on good authority that he did not attend the university. At some point, they decided to withdraw the case, and then they went to the federal court, and they sought similar reliefs. And the Chicago State University, CSU, through the registrar, deposed to an affidavit wherein it was stated that not only did the president attend CSU, but he, in fact, graduated with high honors in a very rigorous major, accounting. He was one of their best students, and no wonder he was hired directly out of college. So confronted with this information and being reluctant to beat a retreat, they pivoted and went in the direction of, the certificate that he presented to INEC was forged. Now, the university came out and said, this is their practice. Diplomas are merely ceremonial documents. What is important to them and to many universities in America is the transcript. It's in the transcripts that you see the grades, that you see the courses that they took, and everything related to the student, and all that you need to know about the student, basically. But the diploma is merely ceremonial. It's for the day, that they graduate, and if you need a replacement, you apply for it and you get it. So the university said the practice is, once they give it out, they don't retain copies. So having given out the version that the president submitted to INEC, they did not have it in their possession. Now, at some point, the president requested for a replacement diploma, as some students do. Now, it was prepared, but the president did not go back to pick it up. It was asked of the registrar, why did he not come and pick it up, and or why did he not ask that it should be sent to him? And he correctly answered, why don't you ask him? I'm not in a position to respond to that. So one Mr. Enahoro Ibar came from Nigeria and requested that a copy of the certificate be handed, a copy of the president's certificate be handed over to him under a subpoena, which was obtained illegally. He had no rights to do that. What he did was wrong, absolutely wrong, and the university knew that what he did was equally wrong. He had no right to get what he got. Now, especially since the president was not notified. Under FIPA laws, he should have been notified, where he could have asserted his rights to intervene and push back if he wanted to. Now, the university, the only certificate that they had on their file for the president was the one that he did not pick up. The university made a copy of it and made it available to Mr. Enahoro Ibar. Mr. Enahoro Ibar did a lot of gymnastics with it, went to the federal court in Abuja, or FCTI court, I don't know which one they went to, but went to a court in Abuja, asking that the president should be prosecuted, blah, 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 and a matter that didn't go anywhere predictably. Somewhere along the line, he was in cahoots with the camp of Waziri Abubakar, and he provided it to them. And then, as a late measure, they now adopted that as part of their reply to the petition. It was not part of their petition. They only adopted it at the later stage, which is not allowed under the electoral laws. Now, they now went to the federal court in the U.S. and said, "Hey, after the school had said, we don't have that he graduated." They now went from that and now said, "Okay, let us have a copy of what you gave Mr. Enahoro Hiba," which was also produced. Now, Mr. Enahoro Hiba and the legal team of Abubakar Atiku, their belief was that the university only had one certificate for the president, which was the one that was presented to Mr. Hiba. And with that, they now, in their minds, believed that the one that must have been presented to INEC was forged. What they failed to realize was that in America, it's not just one diploma that is issued for all purposes. You can have as many diplomas as you wanted. If you want to apply for it, all you have to do is to pay for it. So, and the university, they only have in their possession the diplomas that were not picked up. Just as in the president's case, there were some other students who applied but did not pick up their diplomas, and these they made available to Waziri Abubakar's lawyers for comparison. And if you look at them, I mean, I think social media is awash with all of these documents. If you take a look at what was issued to the president and some of the samples that the university found, you see similarities. They are very similar. So they're very similar. Honestly, to me, with all sense of responsibility, to me, honestly, this is all what they would call silly seasons. It just doesn't make any sense. If the president had not attended the school, that would have made a whole lot of sense. But having attended, and the university having come out to say, yes, he attended, and the university coming out to say, we issued out the diploma, and we don't have that on file because we gave it to him. It's not just him, it's the other students too. And then a classmate, someone who attended the university the same time that he did and studied the same program, deposed to an affidavit and said, I knew him, we were in the same class, we took the same courses, and we participated in a very tightly contested election, and he won. The same person who won, who defeated me, is the person who's the president of Nigeria today. I mean, one would have thought that would be the end of the matter. But now they're saying that they want to go to the Supreme Court to introduce fresh evidence. I mean, the question that should agitate the minds of lawyers, especially those who are very familiar with litigation regarding election petitions. First of all, you're going to the Supreme Court to do exactly what? To introduce fresh evidence. First of all, at least I know two of the lawyers representing Waziri Atiku Abubakar. I don't know them personally, but professionally. They are two of the finest lawyers that you find in the person of Chief Chris Uche and Mr. Iyitayo Jegede, SAN. I mean, these are very serious, highly knowledgeable lawyers. Chief Chris Uche was quoted by the Court of Appeal in their decision. If you look at pages 573 to 575, I believe, Chief Chris Uche wrote a foreword in respect of a book titled Modern Nigerian Election Petitions and Appeals Law. It was published in 2017 by one Kelechi Peter Ikoroga. Chief Uche, a very fine lawyer, wrote in there that, and it was quoted in that judgment, that at the time you are filing your petition for purposes of election matters, that is when you put in all that you need to put in. You file everything along. You're filing your petition, you file your witness statement on oath, and then you stipulate the list of documents that you intend to rely on in proving your case. And in some cases, you even front load. But certainly, if you don't front load that particular evidence, facts relating to it and the list of the evidence that you're going to rely on must be stated. This was not done. This was not done. If you look at the petition, they had the petition was founded on 4 grounds. Now, they're talking about the failure of the president to secure 25% of votes in Abuja, overvoting, the failure of INEC to upload results, and D, that the president was not qualified to contest the election. That was it. Now, in the written witness statement in support, none said anything about D.
Mr. Falabi,
Yes.
let's speak these issues one after the other. So the U.S. District Court for the Northern District of Illinois ordered the CSU to release the academic record of President Tinubu. But for the sake of clarity, what sort of documents were released by the university?
Virtually everything that was in the file. That was everything that was given to them. Everything that was in the file. They got everything that was there. That's it. All of his grades, his transcripts, everything.
Well, if you say everything, what and what documents were released? Please be specific.
Okay. Number one, the released is the transcripts, which showed clearly that he took courses from the school and that he graduated. His transcript from the junior college I attended, Southwest College, was equally released and handed over to them. His application letter, wherein he checked off the box mail, was released. His letter of admission, wherein he checked off the box, wherein it was addressed as Mr. Tinubu, was also released to them. So, and also they also gave them samples of diplomas that they issued, some of which they issued around about the same time. So those are the things that they handed over to Alhaji Abubakar's lawyers in Chicago.
All right. But many were taken aback by the president's lawyers' appeal to the court that releasing his academic record will damage him irreparably. Why did they say this to the court?
Oh, thank you so much for giving me the opportunity to comment on that. You see, that was a lawyer's language, as legalese. Now, any lawyer that you speak to who's a practitioner will tell you that when you approach the court of law to get interlocutory reliefs, that is, after someone gets a judgment or a ruling against you and you want to appeal, so you can go to court and say, we want a stay of execution, meaning don't do that thing before this appeal or this review, as in this case, is done. So essentially, one of the things that you have to satisfy the court with is this. You have to tell the court that, look, Your Honor, if you go ahead and you allow these documents to be released now, irreparable harm would have been done. What does that mean in everyday language? It means that once the genie is out of the bottle, you can't put it back. Now, if you say the decision, we contested that based on FERPA laws, Federal Educational Rights and Privacy Act, that a student is entitled to protection, that a student's records are entitled to protection. That was what we maintained. I have 3 kids here. 1 has graduated college and 2 are still in college. I don't have access to their records. I can't go to their registrar and say, hey, I'm paying tuition, turn these things over to me. No, I can't do it. I can't do that. So we maintained that under FERPA, the president is entitled to privacy to his records unless he elects to release them. So the Magistrate Judge Gilbert, having ordered that the documents be released within 48 hours, were just a few hours away from reaching the time frame. So we went to Judge Maldonado and said, Your Honor, put a stop to the execution of this order. Because if you don't, and these records are released, then there will be no basis for you, there will be nothing for you to review anymore. That was all that we meant by that. Not irreparable harm as in being shot or being killed or no. It's a legal term. I mean, you must, if you are asking for a stay, you have to demonstrate that if this order is not granted, then, Your Honor, there will be nothing before you to review. And the judge listened to us and granted that order. The judge said, yes, the judge agreed with us that if I don't stay the execution of the order of Magistrate Judge Gilbert, and these documents are released right now, if you come back to me, then there will be nothing for me to preside over. There will be nothing for me to be spent. It will be spent. So that was what that was the context in which it was used. And lawyers do that every single day in both jurisdictions. I mean, it's done in Nigeria, once it's a common law country. It's done in America. It's just a requirement of the law. I mean, it's just, for example, now, let me give you a practical example. I mean, you go to court, you have a land case, someone is building on you, someone is about to build on your land. And then you go to court and say, my lord, I need you to stop this individual from building on my land. And you say, one of the things that will happen is if he's not stopped, irreparable harm will be done to me. What do you mean in that context? The land, the topography will be changed. And maybe you wanted to build a bungalow. That was your plan. All right. And then the person, the adversary, now built something else. So that was the context. There was no physical harm, no threat to life or anything.
So,
like
Mr. Afolabi, I asked that question because there are those who thought his lawyers said that just to stop Atiku from achieving his aim, or the lawyers have anything to hide.
Absolutely not. I mean, the lawyers did what the law enjoins them to do. It happens every single day. Once you bring an interlocutory application, that's the first thing you demonstrate. Irreparable harm will be done. The nomenclature will be changed. The narrative will be changed unless this is put in place. And the judge did exactly that. She put a stay and said, okay, come back and address me, which we did. Ultimately, she agreed with Magistrate Judge Gilbert and released the document. And at that point in time, we could have appealed. There was not an appeal. Magistrate Judge Gilbert did what he had no powers to do in law. Being a magistrate judge, he could not have made a dispositive order without running it by the supervising judge. And she agreed with us on that too. And that was why she had it de novo. We started all over again. So, I mean, people just took that and ran with it. You know, that took it completely out of context. So we said, put a stop, stay, and it was granted because it was the right thing to do. There's this thing called res, R-E-S. Lawyers will tell you, if you don't grant a stay, the res will be destroyed and irreparable harm will be done. That was all that we did. Right, there was nothing right. All right. Thank you.
So one of Atiku's requests was the release of a copy of the diplomas issued in 1997. And the university said they matched the format of the replacement dated June 27, 1997. Why is there so much contention about its authenticity?
You see, the way that I see it, as I said earlier, there's nothing there. There's nothing, and his lawyers know. These are fine lawyers, and I can tell you that for free. There's nothing there. I mean, someone graduated. He went to school. The school said he did graduate. A classmate said he did graduate. The school said, we have given him the diploma. Whatever he elects to do with it, that's on him. We don't have a copy of it. Can you even speak to a document that you don't have a copy of? You cannot in law. Alhaji Abubakar's lawyers, they know this. They are fine lawyers. You can't speak to a document that is not your person. Did you create it, Mr. Westerberg? No, it was created before I got there. Did you hand it over to him? No, it was handed over to him before I got there. So what was he supposed to say? Outside of, okay, he was presented with a copy. He saw it and he said, okay, yes, this matches some others that were not previously picked up. Look at them. They're the same. They're the same format. I mean, initially, the Alhaji Atiku Abubakar's lawyer, his argument in open court was that they were challenging it because there was a misplaced comma. I mean, that got a chuckle out of the judge. Like, really, seriously? Yeah, he said there was a misplaced comma, that it was grammatically incorrect because there was a misplaced comma. I didn't hear him say that again when other versions were produced. Other versions were placed the same way. So it is just a question of chasing shadows. I mean, honestly, I will not preempt the Supreme Court of Nigeria, but again, the laws are very, very, very clear. Very, very, very clear. And as I said, Chief Chris Uche is on record as having written, and he relied on decisions of the Supreme Court, that this is the law and you cannot do otherwise. And truly, he was right, because that is what the law says. And even leaving that tonight, let's address the merit, please, for a minute. You are alleging forgery. How do you prove forgery? You must plead forgery, and you must plead particulars of forgery. You have to plead particulars of forgery, and you have to prove it. So how do you in your petition, there was not a single mention of CSU, not a single mention of CSU in the petition. You can take a look, it's a public document. Now, you didn't say anything about Chicago State University. You didn't say anything about forgery.
All right. Mr. Afolabi, let's take a break. All right, let's take a break. I've been speaking with President Bola Tinubu's lawyer, Wole Afolabi, for discussion on Atiku Abubakar versus President Tinubu and all of the facts surrounding the Chicago certificate matter. When we return, we will dig deeper. Stay with us.